Today, we're going to precisely map out the legal framework that authorizes and limits your crucial work in local public health. Let's dive right in by acknowledging the core philosophical tension that defines your jobs. Every single time you convene, you're constantly weighing two vital imperatives on a scale. On one side, the assurance of the public's well-being and the common good. On the other, the strict protection of individual civil liberties. Promoting community health frequently bumps up against individual rights, and honestly, navigating that exact balance is the absolute essence of public health law. Here's our agenda for today. We'll start with the sources of legal authority, then move to federal health powers, examine state powers and limits, look at navigating federalism, and finally cover our specific Colorado health landscape. Section 1. Sources of legal authority. American power is literally split into three distinct parts. We call this the separation of powers. Think of Congress, the President, and the Supreme Court as different buckets.
Different jobs, same team. The legislative makes the laws, the executive implements them, and the judicial interprets them.
But wait, what keeps them fair? Checks and balances. They literally watch over each other to stay completely equal. Like, the President can veto a law, but Congress has to confirm judges. They keep each other in check. It's all about balance. When we talk about legal authority, remember that it cascades downward strictly. At the very top, acting as the supreme law of the land, is the U.S. Constitution. From there, power flows down to federal laws and agency regulations, then to the state constitution, state statutes, and state regulations, before finally reaching your specific domain, local laws and regulations. And a quick but super vital reminder for your boardroom: both laws passed by legislatures and regulations passed by agencies carry the formal force of law. Moving to Section 2, Federal Public Health Powers. Now, here's a somewhat surprising constitutional reality. Public health is actually not an enumerated federal power. Unlike coining money or declaring war, which are explicitly listed as powers granted to Congress, the Constitution doesn't mention public health at all. So you might be wondering, how exactly does the federal government do things like approve vaccines or regulate pollution? Well, Congress functionally regulates public health through two main avenues. First, the Taxing and Spending Clause allows the federal government to set conditions on funding to encourage states to adopt specific policies. Think of the Minimum Drinking Age Act of 1984 or Medicaid expansion under the Affordable Care Act. Meanwhile, the Commerce Clause allows Congress to manage cross-border health issues. This is how we get FDA drug manufacturing regulations and environmental protections through the EPA. Furthermore, the Necessary and Proper Clause facilitates that federal reach. It literally allows Congress to enact laws deemed necessary to carry out those enumerated powers we just discussed. This is the exact legal foundation for the creation of massive entities like the Centers for Disease Control and Prevention, the CDC, as well as sweeping regulations like tobacco labeling and advertising rules. Section 3. State Powers and Limits. This brings us to the 10th Amendment, which is really the foundational bedrock of your authority as a public health entity. Because public health wasn't delegated to the federal government, this amendment dictates that those powers are explicitly reserved for the states. In your daily operations, this means the 10th Amendment grants what we call reserved powers to the states, forming the state police power. This is the core authority you use to promote three big things: health, safety, and welfare. So when you implement disease prevention measures or enforce sanitation rules in your county, you're directly exercising the state police power. But remember that balance scale we talked about at the very beginning? Well, we immediately hit a strict constitutional boundary, and that's the Fourth Amendment. The right of the people to be secure against unreasonable searches and seizures is a hard limit on your police power, specifically designed to protect citizen privacy. You can't simply bust down doors in the name of public health. So how does this balance actually work in practice for Health Board? The law categorizes your actions differently. For instance, conducting warrantless establishment inspections of licensed businesses, like restaurants or body art studios, is generally totally permitted under your reserved powers. However, stepping over into individual surveillance or enforcing an individual quarantine requires strict legal oversight. Section 4. Navigating Federalism. When federal and state public health authorities intersect, the baseline rule is the Supremacy Clause, which results in a concept called preemption. Simply put, if there's a direct policy conflict or difference between federal law and state law, the higher level of government wins and the federal law is going to prevail. But look, while preemption exists for direct conflicts, Our system of federalism is highly overlapping. It's kind of like a giant Venn diagram. The federal government has its delegated powers, the states have their reserved powers, but the middle is full of shared concurrent powers. Things like disease surveillance and reporting, or emergency preparedness and response. These are areas where both levels of government operate independently and simultaneously. This dual system inherently allows for vital local control and state-level innovation. But inevitably, it creates friction and legal tension between state and federal governments. Section 5. Colorado Public Health Landscape. Supreme Court Justice Louis Brandeis once famously referred to states as laboratories of democracy. This basically means individual states can experiment with innovative policies on a smaller scale before they're adopted nationally. Colorado has been a prime example of this, notably when the state utilized its reserved powers to legalize recreational marijuana. This localized decision sparked a massive nationwide debate and deeply influenced laws in other states, completely showcasing the power of state-level public health policy in action. Beyond that highly visible example, Colorado exercises its police power in specific ways that dictate your current reality. Back in 2008, the state created a restructured local governmental public health system, which granted local boards of health the exact increased localized autonomy you currently wield. Colorado law also stipulates that local agency directors must be medical professionals, or at least have a medical officer on staff. At the state level, Colorado uses its authority to mandate that school districts teaching sex education use a comprehensive curriculum, and it requires health insurers to cover services like doulas and community health workers. These are all direct, everyday manifestations of the state police power. As we wrap up this explainer, I really want to leave you with a central question to consider. The legal structure gives you immense power to shake the health of your communities, but it also imposes strict boundaries. As a local board member, how will you continuously weigh your state-granted authority to protect the common good against the strict constitutional rights of your community members? Keep this legal and ethical balance at the forefront of your minds during all your upcoming policy decisions. Thank you so much for your time today and for your ongoing dedication to the health of Colorado.